But let me now go to the issue of investment protection. This is something that has been very present in my mandate from the first day. Some of you might be familiar with the acronym ISDS. It is clear from the debate that there has been and is a fundamental lack of trust by the public in the fairness and the impartiality of the old traditional ISDS model. And this is a fact that has significantly impacted the public's acceptance of ISDS and the companies bringing such cases. Investment protection as such is an important element of EU's investment policy. We need investments in Europe, and the European countries are the most frequent users of the existing system. So it is logical that we, from the EU side, take the lead in reforming and modernize this system. And how do we do that? Well, in the many discussions I've had the last year and the many responses we have received in public consultations and different discussions, the answer is clear. We need to introduce the same elements that lead citizens to trust their domestic courts. This is the only way to establish trust in this system. So what we are proposing for the TTIP text is the creation of a court-like system, one that is accountable, transparent and subject to democratic principle. And the new investment court system offers this. And let me tell you about the content. We will have, first of all, judges, not arbitrators, who will sit on the cases. They must have qualifications comparable to those found in national domestic courts or international courts. We base our proposals on the qualifications required for the members of international courts, such as International Court of Justice or the WTO appellate body. Second, the judges will be publicly appointed by the EU and by our partner country in advance. Their appointment to hear a particular case will be random. This is just how domestic courts and international courts works. And, like in those courts, it would not be possible to choose which judge to hear your case. Third, there will be a guarantee that there is no conflict of interest. Again, like in domestic and international courts, the judges will not be able to continue any activity which might interfere with their judicial functions. And importantly, the judges will not be permitted to work as lawyers on investment cases. We also, fourthly, introduce an appellate mechanism, an appeal tribunal, just like in legal systems and the WTO. All this will be done in a system that is even more transparent than in domestic courts. All documents will be online, hearings will be open to the public. Some have argued that the traditional ISDS model is a kind of private justice. What we are setting out here is a public justice system, the ones we are familiar with our own countries or international courts, and Europe has always promoted international courts. It is not private justice. As a bigger part of this reform process, the Commission is in parallel working to create an international court for investment, but this will take a little bit longer time. I'm convinced that this system of public justice will benefit investors as well. The new system will create the necessary trust needed by the general public that the rulings of the investment court system will be fair, resulting in greater acceptance by the public of the findings. And this will have a positive effect on the investment climate. We're not only proposing to change the way dispute settlement works, but also to tighten the investment protection rules. And that's the last but very important part of the reform I want to touch upon. Many have voiced concerns not only about the procedure, but also the content of the rules. And here I can provide assurances that the right to regulate will be fully respected and enshrined black on white in the legal text. It is clearly stated in the Commission's draft text that the right to regulate for public policy is fully preserved. And that's a direct instruction to the judges, which the appeal tribunal will ensure is properly respected. The proposal of an investment court system is the result of many consultations, many comments, many ideas received from a broad range of stakeholders. We've had extensive debates and discussions with public consultations, detailed discussion with member states and the trade ministers, the European Parliament, national parliaments, etc. And we have taken on board many of these comments and also taken into account the suggestions in the European Parliament resolution that they issued in July. I believe that this proposal meets the expectations for reform expressed by the last 18 months by member states, the European Parliament and others. And we are we are delivering what we promised. I promised a reform system already in my hearing a year ago, a new, transparent and fair court system based on democratic principle that no one can claim is a system of private justice. This is, of course, not the end. I will now discuss this text with Member States and the European Parliament, and when we have completed this round of discussions, we will present the formal EU text to the US, because TTIP will be the first possibility to introduce this system, but it will then be included in all ongoing and future free trade agreements. We have also taken the unprecedented step to immediately publish this proposal in its entirety, so you and the public can see exactly what we are proposing. And this is, of course, important in order to show that we are serious about continuing the transparency. So this work is the result of close cooperation within the College, with all my colleagues have been informed and engaged, but notably with the input of First Vice President Timmermans, who has been of great help. And it delivers on one of the early commitments of the Juncker Commission. Big change is what many citizens and stakeholders have called for. We agree, I agree, and we have taken this path, and we are committed not only to have this system in place, but also to take the lead in the process globally. Thank you very much.